Welcome to the Jones Zone, a podcast by Darryl and JJ Jones.
Hello, everybody. Welcome to another episode of the Jones Zone. Today, we've got Stephanie Kitzes. She's an estate planning attorney. She's fantastic. She's my estate planning attorney. I'm telling you, she's got a wealth of information. So we're going to dive right in. Stephanie, thank you so much for being on today. I really appreciate that.
Thanks for having me.
So, okay, I've got a list of questions that I'm thinking that people out there would want to know the answers to. So I'm just going to start shooting. You ready?
I'm ready.
It's funny because we're not actually allowed to answer this question. We were told this back when I got my real estate and my broker's license decades ago, that you can't even advise your buyers on how to take title because it's considered a legal question. So what are the different ways that one can hold title in the state of California to their property?
It's really important because they take on a lot of meaning aside from just how it looks on the piece of paper for your deed. So generally, you can hold it if there's more than one person, tenants in common, joint tenants, community property. You can hold it in your trust, or you can put the property in a business and have the business hold the title on the deed. But there's big implications for how it all happens. For instance, the tenants in common. So two people, they own the property together. Could be husband and wife. It could be Bob and Sally who never met each other. Who knows? But two people own it. Two business entities own it. And it's tenants in common. That means that each party could sell their part of the property. So if it's half and half, they could sell 50%. You could end up owning that property with someone you don't even know or like. Also, one person could give it by their estate plan to somebody else. Again, you might end up owning the property with someone who you can't work with or deal with, but there's no right of survivorship. So it doesn't matter whether the other owner is still around or not. It's like a separate piece. They can cut that off and sell it on their own. Versus joint tenants is when two people own it, the survivor gets the property when the other person dies. So if Bob and Sally own it and Sally dies, Bob automatically gets the entire property and he just needs to file or record a couple of documents with the county recorder's office.
I don't think this happens, but would the taxes, do you know if the property taxes get reassessed at that time in a scenario like that?
They would get reassessed for the other person's part of it.
Okay.
So if you have two joint tenants, Bob and Sally dies, Bob's original 50% isn't going to get reassessed, but Sally's 50% is going to get reassessed.
So if the married couple were taking title, because it used to be joint tenants would be, but is there another caveat to that? Joint tenants? What does a married couple do? So for example, married people, and then let's say a spouse passes away, they don't have to worry about the house being reassessed, or do they?
They don't, because it's community property, and that's different because it's a spousal transfer. That would only be if there's two separate people, but hopefully everybody keeps it in a trust so they don't ever have to deal with this in the first place. But that's what happens if you hold it in somebody's name. The other way a married couple can take the property is they can hold it in community property with right of survivorship. And that's just like joint tenants, but it's another way for married people to hold the property together if they're both named on it. But truly, if you own property in California, you want a trust to put that property into. Then you would hold it as Bob and Sally as trustees of the Sally Family Trust.
That makes sense.
A whole lot. It's just so much easier and better for everybody involved.
Are there typical situations, I know nothing's guaranteed, but where one would hold it in tenants in common? Is that kind of if you have a business partner? Is that kind of how that looks? Or you're investing with a friend, something like that?
Yes, in both those scenarios. Another scenario is when people get divorced. If they're holding on to a property together for whatever reason, they probably don't want their ex-spouse to just get their half of that property if they die. So tenants in common is often a situation that happens with that.
And tenants in common, you can, like you mentioned, you can sell your half, but on joint tenancy, you can't sell a half, right?
It has to do more when somebody dies.
Okay.
But, yeah. And with joint tenants, if you sever that and you sell your half, you're going to end up with tenants in common.
All right. That's probably enough to just get people interested. If they have any further detailed questions, they'll have to contact you for those more specific. So question number 2, what are the key benefits of holding a real estate in a trust compared to other forms of ownership?
Anyone in California wants to hold their personal real estate in a trust, in their family trust at least, that avoids probate. It's huge if somebody passes away. Because for instance, had a client, their property was not in trust. They didn't get to me in time. So they came to me after the fact. Parents died. The property was not in a trust, had to go to court. There was bickering about who was going to be the executor, who the court would approve. So time went by, months went by.
Just to interject, while you're waiting, you still have to make any sort of mortgage payment, association, insurance, taxes, all that stuff. So, okay, go ahead.
Exactly. Yeah. And in this situation, the siblings were fighting, so nobody paid it. So the house actually went into foreclosure.
Oops.
Yes, exactly. And the other thing is, I had another situation kind of similar, but the siblings were getting along and everybody was trying to do the best thing. But the siblings, frankly, didn't have enough extra money to come up to cover the parents' property taxes, mortgage payments, maintenance on the house. That's another situation where a tax lien was filed on that house. All that can be avoided if everything is in a trust, because then if it's in a trust and everything's properly documented and funded, the trustee of the trust can automatically start making payments from parents' account. They don't have to front any costs. Huge difference, both in cost and in time.
I was going to say, and people probably, I mean, lack of knowledge and then also thinking it's probably be super expensive. I think it's important to realize, and I think you've kind of made this point, as much as you may think, well, I don't want to go pay for a trust. Well, you're going to pay for it one way or another, or someone is. And it's actually less expensive putting it into a trust, possibly, and more than likely would be less expensive rather than have it go through probate in most cases.
I mean, in 99.9% of cases, it's going to be a lot less money, exponentially less money to just put it in a trust in the first place.
What happens to real estate when the title is not held in a trust and the owner does, pass away?
If it's a personal property or if it's an investment property, it's going into probate, whether you like it or not. There's no way around it if you don't have a trust set up and it's not funded to the trust. Now, something could be not titled into the trust, but you could have actually made a trust, but the attorney or whoever it was never actually put the property into the trust. When you do an estate plan, it's a big part of it. It's only going to work as well as you've done a job at funding those assets to the trust. And what I mean by that is that, for instance, whenever I do an estate plan, part of that signing, when the clients come in to sign their estate plan documents, always includes deeds for their real properties. Those deeds say that they're transferring it from themselves personally to themselves as trustees of their trust. It's called being funded into the trust. It's actually in the name of the trust. That's the only way you're guaranteed that you can operate without probate.
So not only do you need to name it in your trust, the property address, et cetera, but you have to have that property also hold title in the trust as well.
Absolutely.
Yeah.
Absolutely.
Okay.
It's critical. It's critical. Now, in California, I don't know about other states, but in California, we have a probate code and a case law that says that if you can prove that the property was meant to be in the trust, but never actually maybe got the title changed to the trust, you can do an extra petition. That's not a full-blown probate petition, but it's a petition where you ask the court, hey, this was in process of being funded. You can see by the documents that they meant it, and ask the court to deem it an asset of the trust. Now, if that happens, you can avoid probate, but that is a process in of itself. You still have to draft the petition. Right now, you have to wait about 4 months for a hearing date in Orange County, and you're stuck till then. And then if it doesn't work and they say, no, this isn't enough, we're going to have to probate it, then you got to start back at the beginning of probate. Right now, probate in California is taking, they say 16 months, but I've never seen one go by that fast. It's about 2 years, if not longer. I have several that have been going on for 3+ years. Things come up and it really slows it down. In California, there is something called a small estate affidavit, which people rely on. That says that if the whole estate is worth less than $184,500, then you can just basically fill out this simple form and avoid the full-blown probate. But real estate, anybody owning a property, you're not going to be under that amount.
I was going to say that's,
it's just not going to happen.
The Mojave Desert.
Yeah. And even if people don't own real estate, the odds are that they're still going to be over that amount when you add everything together, because you're looking at gross, not net. You may owe $900,000 on a $1 million house and think, oh, I'm okay because it's only worth $100,000. But that doesn't work because, one, it's real property, and two, they look at the gross value, not the net value.
Oh.
So they're looking at the $1 million value.
So get a trust.
get a trust.
So how does the probate process work in California, real estate that's not held in a trust? You talked about how it's even taken 16 plus months. So what exactly happens when someone owns a house and they unfortunately pass and they inherit a house that's not in a trust?
So what happens is somebody steps up. If they have a will and not a trust, hopefully the will names who the executor is. If they don't have a will and there's no executor, then someone else hopefully steps up and files a petition with the court. And then once the petition is filed with the court, there'll be a hearing as to who the court is going to appoint. You might have a will and think, no, I know Sally Joe's going to always be the executor. The judge may, for whatever reason, appoint somebody else. That's one area where the family can already get into conflict as who wants to be in charge. So once that's decided, things move forward. And that person has to get everything appraised. That person has to publish notification in a public newspaper saying that so-and-so has died. And if you have a claim against them, to go ahead and make an issue of it. But it all becomes public knowledge. They have to track down and search for any beneficiaries or potential people out there and kind of marshal all the assets. Meanwhile, you're getting court hearings set out every 3 to 4 months. And the judge is going to check in and say, where are we at? What's left to do? If you want to sell property, you may have to go and ask permission if you want to do it before the probate is over, things like that. But the court is monitoring it and you have to ask for permission to do certain things. With the trust, you don't have to do any of that. You still want to, marshal the assets and get them appraised for tax purposes. But there's no one you have to go to ask for permission to sell a property or to make a partial distribution. So meanwhile, you're in court, it's going along, things are getting pushed out. During COVID, almost nothing happened. Those are the ones that have gone on 3-4 years. They're still going on. And eventually you arrive at the end where you do a final accounting with the court, and the court issues an order saying, okay, this is how everything can get distributed. If the person had a will, they usually go by what the will says. But if there's no will, then it just goes by law as to who the person's heirs were.
You've told me about this. This is interesting, but go ahead and expand on that.
So if you don't have a will, who gets your stuff, right? It goes by, it's like a big chart in California, but basically if I die, my kids would get it. If I don't have any kids or grandkids or anybody underneath me, then it goes up. It would go up to my parents. If my parents had already passed, then it would go sideways to my siblings.
I had a situation like that happen and it was tragic because he would have definitely wanted only one parent and or a sibling to receive the property, but it ends up going to someone he wishes he wouldn't have had it. But anyway, I'm sorry. Go ahead. Continue.
No, that is exactly what happens, though. I mean, it just keeps going out until it finds somebody. But often you have people who they never even knew they were around or they never met them. I had a client who said, I just got a call from this guy and says, I'm going to inherit. It was almost $200,000. And it sounds like a scam, right?
Yeah.
And so I investigated it for them and it turns out it was true. Some person died on the East Coast. They had never met. It was like 4 generations removed, but she was the next person that they found. And that's how it went.
Wow. I can hear investors or people who are listening to this right now thinking to themselves, I'm thinking about this. What happens if they don't find anybody? Are there properties that are in the state has control over that they just don't know what to do with? Or how's that work?
That happens all the time. If they can't find anybody, it goes to the state. The state holds it in what they call the unclaimed property. And they hold it for so many years. And after that, if nobody claims it, says, no, it's mine, then eventually the state will just take it. So everybody, and it's not just with property, it's with bank accounts, it's with overpaid wireless bills or Verizon bills or wherever you're going to get money from, or you paid to, maybe you paid $5 more. If you go to the California Secretary of State website, search for unclaimed property, and you just put in your name, and you'd be amazed at how many things can pop up. And if something pops up, it's really simple. You just put in your info and the odds are they're just going to send it to you.
Say that again. What is that? Say that again.
So this is what I would do. I would Google.
When someone passes, there's a house.
It could be if somebody passes away, or it could be even for yourself while you're still alive.
And you want to find out if, hey, maybe I have inherited something that I'm unaware of. That's what you're talking about right here.
It could be you inherited something you're unaware of, or honestly, it goes beyond that. It could just be that you got some money somewhere that you didn't know about. Just Google California Secretary of State unclaimed property. It'll take you to a website. Make sure that the website is .gov so you get to the real one. You'll just be able to put in your name, first name, last name, address if you want to, and it'll pull up if the Secretary of State's holding any money for you. I do this periodically for my clients that I have on kind of a maintenance plan. I tell you, just a couple months ago, one of my clients had sold one property and bought another. They had almost $2,000 sitting there in unclaimed property with the California Secretary of State. And it all had to do with like, they paid a phone bill and there was a little bit extra that was paid on the phone bill. AT&T is not going to go look for you.
Yeah.
The gas bill, even escrow, extra money from escrow, an overpayment on a mortgage. And it was all just sitting there.
Wow, that's a nice surprise, I suppose, for people. What are the typical costs and timeframes associated with probate? You mentioned 16 months, but it's even...
16 months is, you'd be lucky in Orange County. I don't know what the other counties are running. LA County is going to be longer than that, I know, but I don't know about San Diego and Riverside or up north. But I think 16 months in California, if everything's smiling down on you, then you're going to go for that.
You mentioned earlier that if you are the heir or you're the executor, is that what it's called? The term is called the executor. You mentioned about publishing something in the newspaper and all this other stuff. Is that something that your firm does, or is there a person that does that for a living? Because obviously a lot of people are busy and they have other things to do. They want to make sure the T's are crossed, the I's are dotted, and everything's done. Can one hire somebody to do that aspect of it?
Yes, I do handle probates. Now there's uncontested probates where everybody agrees. They just got to go through the process to get everything released. And then there's contested probates where everybody's fighting over everything. I do fewer of those, but the uncontested I do all the time. But they're expensive. And I really try, even though I do them and I could, I guess, theoretically make more money on them, they make me crazy because it's an opportunity for families that should be just grieving to get into conflict and have to go to court when they should just be dealing with their emotions and kind of enjoying their memories of the person. And it can turn nasty very quickly, and it's expensive. It's ridiculously expensive. So just to file the petition is $435 right now.
Let's say I'm the executor I'm in the will. And it's a probate.
Okay.
Let's say it's a probate. And I happen to be in the will, and they go, okay, Mr. Jones, go ahead, and Darryl, you're responsible you're the executor. And I'm thinking, oh my goodness, I got a million things I'm doing here right now. I'm not an expert at it. So I would go to you opposed to there's not a field that does that.
No,
executor.
It's something for an attorney who handles
okay.
it. Then I assist, I prepare the petition and the documentation, and then we file it with the court and then handle all the things that come up after that, like coordinating with getting things appraised, coordinating with the newspaper to get the publication out, lodging the original will with the court if there is one, and all the things like that throughout the process. I do advise that somebody works with a qualified attorney because there's a lot of areas where you can mess up. The executor, or another thing they can call it is administrator that the court appoints, is subject to personal exposure, personal liability if they do something wrong.
Ouch.
Yeah. And it's the same actually in a trust. The trustee is subject to personal exposure, meaning that your own assets, like if I was appointed a trustee, my own assets would be at risk, not just what was in the estate. It's not inexpensive, but when you look at that compared to your potential liability, it is.
So what are the typical costs and timeframes associated with a probate in California? I mean, again, you mentioned 60 months or a long time, but what's a cost?
Well, it starts out with $435 when you're filing the petition. That's just the fee that goes to the court for the pleasure of filing the petition with it. You're going to pay for appraisals. You're going to pay to publish the required notice in a newspaper. Of course, you'd have to pay for the taxes and everything else and the CPA fees that come with it. The interesting thing about probate is that the executor fees and the attorney's fees are by statute. Means that the statute sets the expense. So for instance, if the first 100,000, it's 4% of that. The second 100,000, it's 3% of that. The next 800,000, it's 2% of that, which means that for a $1 million estate, it's $23,000. And that's $23,000 to the attorney and to the executor. So you're looking at $46,000.
Oh, ouch.
When they're combined.
Right.
And our $2 million estate would be $33,000. $5 million is $53,000. And again, if they had just done a trust for, I don't know, $4,000, give or take, either way, depending on their situation, they would have saved themselves all the rest of the money.
Boy, that's huge.
It's catastrophic. It can actually mean the difference between being able to leave people money or things and not being able for them to actually get anything in the end. It's very expensive.
What are the risks or the downsides, if any, placing estates into a trust or your house into a trust? Is any downside to that?
There's really no downside to that. And that's your personal house. If you're talking about investment properties, then in that situation, I would probably put them in a limited liability company and then put that limited liability company into the trust. It'll help shield you for predator claims and stuff. But eventually, the ownership of everything eventually goes into your trust. Because if it's not ultimately in your trust, then you're going to probate.
What are the only potential negatives of that? You'd have to do taxes every year for that LLC. Is that right?
Yes.
Okay.
You would, but if it's a single member LLC, then it's really minimal.
Okay.
And it's just a pass through. So you're not going to pay additional taxes. And so real estate investors need to start thinking about that. There's ways to deal with it so we can still avoid probate by putting the entity into the trust. And then the real estate investor should be looking at that, should be looking at their insurance and other things to limit their exposure and liabilities.
And an LLC, for those that don't know, is a limited liability. What's the C stand for? Company. Yikes. How does holding a title in a trust affect? Does it affect the property taxes in California at all, particularly like with Proposition 19, anything like that?
Prop 19, in my opinion, is something that needs to get repealed. It's really hurting a lot of people. And holding title in a trust is not going to affect what happens to you in relation to Prop 19. When somebody passes, there's a lot of taxes involved, right? There's property taxes, which Prop 19 concerns itself with. And there's capital gains tax, there's income tax, estate tax, all different kinds of taxes. But in relation to Prop 19, holding it in a trust isn't going to help you. It's not going to hurt you. It really is not going to have an impact.
Stay tuned, everybody, for a future show. In fact, Stephanie was kind enough to refer me to a real estate tax attorney who will be on the show, and he'll probably be able to even expand further on that because, as you said, Prop 19 is hurting a lot of people. Yeah, just not good. So I don't know, unless you wanted to talk more about Prop 19.
No, I mean, he's the guru. He's
Okay.
who I went to when I wanted to go to a seminar on it.
Okay.
And so, yeah, he's going to have all your information. I can tell you in short what happens.
Sure.
Okay, so in Prop 13, which is what we had before Prop 19, that controlled property taxes, whenever somebody inherited property from their parents, they got to keep the base that their parents paid. So if their parent paid $100,000 for a home 20 years ago, and they're only paying $1,000 a year in property taxes, when their kids inherit that property, that's all they pay. They keep their parents' property tax rate of that $1,000 a month, even if that property is now worth $5 million. That stayed the same. Now, that is not the case. Now, it only works if it's the primary resident of the parent when they pass. The child then moves in and uses it as their primary residence.
To further clarify, the child has to move in order
Yes.
to keep the low tax.
Yes, parents must have used it as their primary residence before they passed.
And if there's two children who inherit the property, both of them have to move in order to keep that low property tax rate.
There are ways, I think, and the other attorney will be able to clarify if one can go and take it over that way. But nevertheless, so say that $100,000 house is now worth $2 million when the parents pass. Everything meets the criteria. The parent lived in it when they died. They have one son. The son's going to move into it and use it as his primary residence. He doesn't get that whole increase in $1.9 million that happened. He gets $1 million worth of increase only. So the parents are paying property tax for $100,000. It's now worth $2 million. He'll keep that $1,000 base for that $100,000 plus $1 million, but that extra $900,000 in value, that property tax is going to increase. So what's going to happen is that child is going to go from paying $1,000 in property taxes a year to probably paying about $10,000. 11,000.
Yeah, basically making it cost prohibitive.
Yes. And if it was a secondary property, or if they wanted to use it as a rental and not live there, they're not going to get any protection from any amount. So it's going to go from that $1,000 a year amount to probably $20,000 a year.
Yikes.
It's sad because people aren't able to keep properties. I've had clients, or not my own clients, but my friends' clients. They had a property. They wanted to give it to their daughter when they passed away because their daughter was a teacher. She made steady money, not enough money to buy a house in the area anymore because California has gone crazy, right? But they couldn't afford to keep up the house, or they could afford it, but they didn't have the physical ability to maintain that house anymore. So they decided, we're going to rent it out and move to a 55 and older place and hold it for our daughter. They moved into a, not really assisted living, but
a senior facility, retirement
facility,
community.
A senior facility. And they rented out their old home. So they did that for 10 years and then they passed away. Under Prop 19, the daughter, who could have paid $800 a year in property taxes, was going to inherit this house, and her property taxes were going to be $25,000 a year. She could not afford that and to live, basically. So she ended up selling the house.
Boy, and that's all Prop 19.
That's all Prop 19.
Mm. Are there any specific types of trusts that are better suited for holding real estate in California, or
if we're talking about personal real estate property, really it's your standard kind of revocable trust that you're going to keep it in because you want to maintain power over it while you're alive. If it's investment property, you can look to other types of trusts or irrevocable trusts, but for your home especially, should go into your revocable family trust.
That leads me to something I had thought of. You mentioned how those parents who they went into actually, I'm remembering now, it's supposed to be a retirement community. I've had my other guests that run those, and they said, no, it's not a facility. It's the F word. It's a community. So the retirement community. So they were kind of thinking ahead, thinking, okay, we're going to move into a retirement community. We'll leave this for our daughter, etc. Because I've had people come to me and think, okay, you know what? I'm just going to put my daughter on title. Speak to that a little bit. What's the problem with doing that?
That hurts you with regard to capital gains.
And even if they took half the title, if they just like joint tenants and you just two people added a third person. Okay.
So I've dealt with that scenario several times. And this is what happens. Say the house was valued at $100,000 again when the parents bought it. It's worth $2 million when the parents pass away. If the parents put half of it into their kid's name, then that half, they don't get what's called a step up in basis. And a step up in basis is referring to capital gains. It's different than Prop 19. It's different than property taxes. It's referring to capital gains tax. What the federal laws say is that if you inherit property, you inherit it at the value that it was on the date that the person passed away. So in this scenario, if the parent bought it at $100,000, years later it was worth $2 million. When the child receives it after the parent dies, then they get a step up, and so they take it at $2 million. So if they sell it the next day for $2 million, there's zero capital gains. If the parent instead said, "Oh, I want to, this will be easier. I don't want to pay to do a trust," or "I want to give you a gift," or "I want to reassure you that you're going to get this, so I'm going to put your name on title." Say they did that when the house was worth $1 million and they gave them half. Okay. So at that point, they had half the house, and the total house was worth $1 million. So they have a $500,000 interest. Then when the parent dies, it's worth that $2 million. So, but the child, because they already got half before, is only going to get a step up on the other half, right?
Right.
And since they already own half, then it gets reduced even more.
So bottom line, that's probably happened 1 million times.
So bottom line is in that scenario, if it's not fixed before the parent dies, it's probably going to cost the child inheriting the house at least $200,000 up to $400,000.
Not to mention, I think that it possibly gets reassessed. Maybe the property tax even may go up at the time that they transfer half of it to their daughter, they add their daughter under the lien. Maybe that's a different topic, but
but it will.
Yeah.
It will. It will. So really the way you want to do property is not to put your kids on before you die. You want them to get it through you dying, through a trust after you die. That way for capital gains, they really can pay $0.
That is huge right there.
Hundreds of thousands of dollars.
I mean, have you come across people that thought, "Oh, I'll just add my child and we'll be fine"?
I have. I fairly recently had clients that came up and they said, "Oh, but we think we're okay because, I quit claimed part of it to my kids." I thought, oh my gosh, in this scenario, based on their numbers, it was going to cost them almost $500,000 in capital gains tax if the kids sell the house.
Could they reverse it, or is it too late?
I did. I was able to reverse it. The kids gifted it quickly back to the parent. And then the parent actually passed away. But had we not done that, each of the two kids would have about almost $250,000 in capital gains tax out the window. But because we got it in time and we're able to reverse it, they got to save all that money.
Well, in time, can you shed some light, or maybe there's not a specific time frame, but because hopefully not hopefully, but maybe someone's had done that and is listening to this and thought, oh my gosh, we did that 2 years ago. Maybe I should call Stephanie. Or is 2 years too long, or how's that work?
It's not necessarily too long. There is, Prop 19 and other things to deal with that are going to impact it in other ways. But the thing is that when you look at taxes, you have Prop 19, you have capital gains, you have income tax, you have all these different taxes. You really got to look at it and say, where am I going to save the most? Because sometimes people want to do some kind of fancy work around this Prop 19 to keep the property tax level, but that means they're going to eat it in capital gains.
Yeah.
If you're saving $10,000 on Prop 19, but you're spending a couple $100,000 with capital gains, it's not worth it. You got to keep your end goal in mind.
Yeah, the tax man, well, never mind. I won't even go there. I was going to say, they might not be good at a lot of things, but getting our money, they're pretty darn good at. So, edit, what should any specific trust? What should homeowners consider when deciding whether to transfer their property to trust? Okay, I'll do question number 10. Okay, Jeremy, back in. Okay, so what should homeowners consider when deciding whether to transfer their property into a trust? Any advice on that?
So the only consideration that a homeowner in California should be doing is who they're going to work with as for their attorney to help them to do a good, solid estate plan. Because estate planning really will keep their family out of court and conflict. It'll end up saving them a lot of money if it's done well. If it's not, if it's DIY'd or who knows what, then it really can go south, and it can actually be sometimes more detrimental than having nothing at all. I had a client come to me and said, hey, my friend put me on this will and I'm the executor. And so can you help me, do the probate, or how do we figure this out? And when I looked at the will, it was done, I think, on Rocket Matter or Zoom, whatever, one of the DIY things. And I'm going through it, come to realize that this person gave out his property to like 7 people. Okay. But when you added up all the percentages that were going to the people, it equaled 146%. So it's a mess, right? So sometimes you can do more harm than good. You really want to go to someone who's qualified to do a good job, and who personalizes it to your particular family, your particular situation, and someone who does a lot of like what ifs in their trust, meaning like I do a lot of what ifs. Like, what if somebody is not special needs now, but gets in a car accident and has a traumatic brain injury? What if this scenario happens, or what if that scenario happens? So that you're built in and that you're protected.
It's the old saying, if you think a great attorney costs a lot of money, try using a bad attorney. They'll cost you a lot more. And them being their own attorney, I guess, doing the DY or the do-it-yourself one.
I mean, it's true. I mean, now I think, and I do it too. I'll go on YouTube, like, how do I fix this cabinet at home? That kind of thing. And, there are times when I'm like, why didn't I call a handyman or a contractor who did it right from the beginning? They're trained for it. That's what they do. I mean, I'm not going to go get surgery from someone who looks up how to do it on YouTube. And the thing is that you may think that, no, I went online and I did this, or I went to this seminar and they said if I attended this seminar, I'd get it done for $9.99 trust package or something like that. But I can tell you that there's no way to do a quality personalized estate plan that's tailored to that person for that much money unless you're working for minimum wage. It's that much time is how much time the attorney should be investing into it. And it's really cheap relatively. You're looking at $1 million estate. You're going to pay that attorney just for the attorney portion, $23,000. An estate plan is going to cost you a fraction of that, a quality one. People who do it, they think they did it, right? Like this guy who did his will online, he was proud. He thought he did it. He actually thought he did a trust. He died thinking he had everything taken care of, but what's left is a mess.
Oh, complete mess. I think I had heard just missing checking a particular box or anything like that. Because I think in a refi, for example, I had a client who's got their property reassessed because they didn't check a box or something. Point being is that, boy, you have to be very thorough. They said minor mistakes could cost you tens of thousands of dollars.
It can, and it's sad. It kills me when it happens. I had one person come in with her mom's estate plan. The mom was an immigrant who came with nothing, worked hard, ended up being able to buy her own home, raise her kid, never went on any benefits. I mean, just like salt of the earth person, right? She had heard about trust and needing a trust and all these things. So she went to somebody who she thought was an attorney to do her estate plan. And this person did the estate plan and they brought it to me and they said, okay, well, we have the trust. What do we do now? I looked up the attorney on the search that you can do from the California Bar Association, and that person wasn't there. Turned out that person was never an attorney. That person was a document preparer, someone who held himself out as an attorney. And here's this woman who worked so hard for everything she had. What she was given was not sufficient and was messed up. So he still ended up in court.
And she had passed.
She passed away. And so this woman died thinking everything's taken care of. Her kids and part of her assets went to fixing it, went to the court. I think I waived my fees on that one. But I mean, it was just a shame, right? Because she thought she did everything right. You have to look into your attorney a little bit, or who you think is your attorney, and see if they really are an attorney.
Well, you mentioned a website. Is there something that the public can look at real quickly if they do, to verify that?
You can go to calbar.org or look up the California Bar Association. And in that, if you scroll down just a little bit on the homepage of the website, there is a search where you can put in the person's name to see if they're an attorney. And you can also see if they've ever been disciplined or if they're disbarred, or if they've ever been suspended. I got another one to do, this was a couple years ago, to do an update. And I thought, okay, it's professional courtesy. Call the other attorney, like, was there anything, concerning or whatever? Well, when I looked him up on calbar.org, it turned out he was disbarred 6 weeks after he completed their estate plan. And they never knew.
And I'm guessing that it's not easy to get disbarred. You got to do something bad.
Yeah.
Describe the process of transferring real estate into a trust. It's a relatively simple process, if I remember correctly.
It really is. And for all of my clients, I handle it myself as part of their estate plan package. We usually prepare a grant deed, transferring it to the trust. Literally says it's going from them to themselves as trustees for their trust. We record that together with what's called a preliminary change of ownership report. I record those myself to make sure they get funded. It's my way of making sure that that house gets into that trust. And you have to file that preliminary change of ownership report with that grant deed. Otherwise, you're going to get reassessed.
And that leads me to my next question. What are some common mistakes people make when in holding title in a trust? I mean, you mentioned that. Are there anything else that's really common?
The other thing that I find happens more often than it should, it's happened to my clients. They come in, we do their estate plan, we sign the deed, we transfer it to their trust. And then 6-7 years later, the interest rates had dropped. And so they do a refinance. So when they refinance it, what the banks are supposed to do is they take it from the trust back to themselves personally, and they do the thing, the loan
Refinance.
refi.
Yeah.
And then they're supposed to do a second deed, transferring it back into their trust. I've had numerous times where those deeds were recorded flip-flopped, so the property ends up outside of the trust, or it just wasn't done at all. The bank pulled it out, did the refi, and left it out of their trust. So they think that it's in their trust, but the bank had taken it out during a refi. That's why for my clients, because I stay with my clients on an ongoing basis, because life happens, right? Things change. I tell all my clients, if you ever refinance your property, call me. I'll pull the deed so we make sure that it ended up how it was supposed to be.
How can holding real estate in a trust impact the future sales or the refinancing of the property? I mean, we talked a little bit about refinancing. What about future sales? Are there any pros and cons to that?
Future sales, yes. If you have your property in a trust, that means the trust, as soon as somebody passes away and they get the death certificate, that trustee can sell that property. That trustee can rent out that property. That trustee can pay the property taxes. That trustee can do needed maintenance on that property without anybody or anything or any court having to be involved. So it's immediate access to make that property either earn income by renting it out or to enter into the sales process. So if I get that property into a trust before the person dies, that means that I can call Darryl, which I have for my clients, and say, hey, they are going to sell this property. Dad or mom died a month and a half ago, and then Darryl's on it, and that property is sold faster, and those kids have the money to go out and do what they need to do with it.
An immense savings. It's not even.
Did you hear? Yes. And also time and money.
What are the inheritance implications for beneficiaries when real estate is held in trust versus not?
The main thing is the speed, the flexibility that comes with trust. Another important thing, though, that we haven't talked about before was that it's private. If it's just a will or not a will and you have to go to the probate court, court records are public records. If you have an 18-year-old getting a pile of money, there are predators out there who look at those court records to figure that out. If it's in a trust, there's no need to make a public record of it. And it happens privately. You hear about when lottery winners getting all this money and then everybody comes out of the woodwork.
Yeah.
Happens with estate planning too.
Interesting. So for someone who already owns a property, what steps should they take to ensure their title is held in a trust properly? And also, you spoke about it earlier about how when you refinance, the banks take it out of the trust to put it in their names. And the same thing is true when you're purchasing a property. I've oftentimes had clients tell me, hey, we want to buy it in our trust. And I say, well, you can't. The banks won't do that because for legal reasons, they have to name a person. So you can do that if you're buying cash, but if you're getting a loan, you have to do that with your name, and then you have to transfer it into the trust. So for someone who already owns a property, what steps should they take to ensure that the title is held in a trust?
If they already have a trust, then what they should do is contact the attorney that they worked with, tell them they bought a new property, and that attorney will prepare a grant deed transferring that property to the trust with that preliminary change of ownership report and then record it for them. If they don't already have a trust or any estate plan, then they need to talk to somebody like me or somebody else that's qualified to help them with that and make sure that that transfer of that property is included as part of the services that attorney is going to give them.
Oh, that's good advice. Well, speaking of getting a hold of you, someone did want to get a hold of you. What is the best way to get a hold of you? Phone or email or whatever you say?
Either one. My email is stephanie@kitzesLAW.com. And our phone number is 949-517-2275.
949-517-2275. Well, that's been just immensely helpful. I mean, I'm telling you, this is one of my best, I think, for me at least, because these are types of questions that come up so often with a lot of my clients that this is just so valuable, such valuable information. So thank you so much for doing this for us, and really sincerely, anybody, if you're considering getting a trust, estate planning, for crying out loud, contact Stephanie. I'm telling you, I have personal experience with her. You will not be disappointed. She covers everything. She's very thorough, and your relatives will be the most happy people. Well, they're not going to be happy because you're gone, but you know what I'm saying. So Stephanie, thank you. Thank you so much.
Thank you, Darryl.
For participating. So
thank you.
take care
Anytime.
now.
Thanks.